So welcome back to another video. The purpose of this video is to talk about the options that are open to you if you find yourself under investigation for a drug driving offence. Now you're under investigation if you've been arrested, taken to the police station or the hospital and a sample of blood or urine has been taken from you. Now you can't be charged with the offence of drug driving until the results come back. Only then can the police be sure that you're above the legal limit. Only then are they entitled to charge you with drug driving. And so we have this sort of lengthy period of what can be up to 5 or 6 months until the results come back and until the police lay charges. And the question that people often ask me is, well, do I do something about that right now? Or do I just sit and wait to see what happens? And that's a really important question and a really important consideration for anyone that is under investigation. So that's what we're going to explore in this video. My name's Conor Johnstone. I'm a specialist motoring defence solicitor with M.A.J law, and I've been defending drug driving cases since they were first introduced in England and Wales almost 10 years ago. Now, my personal view and what seems to work really well for us as a firm when we are instructed by people that are in this situation is early intervention. And that's the approach that I'm going to talk more about in this video. There's only ever 2 options for somebody who has been released under investigation for a drink or drug driving offence, having given a sample of blood or urine. The first option, you do nothing, you bury your head in the sand and you wait for the results to come back, and that can take many months because of all the delays, the backlogs and some of the problems that the police have had more recently with the laboratories they instruct to analyse these samples. The other option, a bit more proactive and try and do something at the early stages, perhaps to minimise and mitigate the risk of you being convicted. Now, my own personal opinion, and it's based on my experience defending these cases for a long time, is that being proactive is far better than being reactive. So whenever I speak with anyone that's in this situation, I'd always recommend that we start on the front foot, that we make contact with the police at the early stages. And there's 3 reasons for this, and I call it the 3 Ps. First of all, pressure. Second of all, preservation. And third of all, preparation. And we'll go through each one and break that down. So dealing with pressure to begin with, the police generally aren't expecting to hear from defence solicitors at the early stages of a drug driving case. What they assume you will do is wait quietly in line for the results to come back. The police will assume you're going to be over the legal limit, and most people are, because the legal limit for drugs in particular is very low, a zero tolerance policy. So if you've failed a swab test and been arrested, it is highly likely that you would come back over the legal limit, and the police know that as well. So they expect you to do absolutely nothing, and they'll take their time to analyse that sample. When the results come back, they'll send you a letter in the post with a court date. Despite them taking a good 4 to 6 months to analyse that sample, remember they've only got 6 months to prosecute you, and sometimes you do get prosecuted in the final weeks of that 6-month time limit, so they will certainly take their time, but they'll try and shove you into court as quickly as possible. And I often receive calls from people that have received charge documents, postal requisitions for court dates, and they might be in court the same week or a week later. And it can be very difficult to make arrangements to be properly prepared for that court date, to gather evidence ahead of the court hearing so that we know what to expect and so that we know what the best approach might be on that court date. So for that reason, you always start on the front foot. And dealing with this point of pressure, it really is about putting some pressure on them where possible. So I may write to the police and start raising some initial concerns about the adequacy and the accuracy of the evidence against you. Having had a conversation with you, we might identify some potential problems with the evidence or mistakes that we think may have been made when the evidential sample of blood was taken from you at the police station. We don't just sit on those issues and sit on those arguments until a court date. If you've got a good hand, you play those cards at the earlier stages. So we write to the police early on and we start putting some pressure on them, raising these concerns, because they're not normally expecting that. So it is really about being a little bit of a nuisance, creating and causing some practical problems. Now the hope is that the police may look at the case, realise what's involved, they know it's going to be an uphill struggle. We've given every indication that we might enter a not guilty plea if you are charged with the offence, and these are all good reasons day to day why the police may decide not to prosecute. And we are in very different times than we used to be. In the past, many years ago, certainly when this first became an offence, practically every drug driving offence went to court because the police were very excited about it being a brand new offence. They wanted convictions on record, they want to get people in court, and they want to impose driving disqualifications. But now it's a very different situation. having dealt with COVID many years ago, back in 2019, 2020, when all the courts closed down, there's a massive backlog now of criminal cases. I think the most recent estimate was around 500,000 criminal cases waiting to go to court. And with that comes a whole host of different problems. Administration issues, of course, staffing shortages, a lot of prosecutors and police officers that are on a long-term sick leave. What we saw last year and probably going into this year as well, strike action, industrial action. So what we're finding is that the police just don't have the sort of interest or energy levels, the manpower, the resources that they had in past times. And that is putting them under a lot more pressure with these lower level offences. So they may decide, all things considered, that you're not going to roll over and plead guilty, or because you're not just going to roll over and plead guilty, that it's not a case that's worth prosecuting. And the police do have to make difficult prosecutorial decisions every day at the earlier stages, and lots of our cases don't go to court for that reason. So the first P out of the 3 Ps is pressure. We always want to put pressure on the police at the earlier stages of a case, and if you can win the case or get the charges dropped, that may mean that you don't have to go to court, and that also means, of course, then there can't be a driving disqualification, a criminal conviction, and the consequences that come with it. Now, the second P is preservation. One of the problems with doing nothing at the earlier stages is that we run the risk of actually losing some really valuable evidence that might help us at the later stages. One of the most effective ways of defending a drug driving case is on procedure. I touched upon that a second ago, what's called the M.J. procedure, the way in which that sample of blood was taken from you at the police station. And there's a very strict and prescribed process of how that sample is taken, what kind of information you have to be given, what the officer has to say to you, and when. So words spoken, things done, the officer's actions, the actions of the nurse, all play a really important part in how we challenge and defend these kind of cases day to day. Now, thankfully, most of what happened at the station is on camera, whether it's CCTV or body-worn video footage, and that's some of the best evidence that we can hope for, because it's up to you whether you trust what a police officer puts in a witness statement. But we have found that in the past, a lot of the statements that come from police officers in these kind of cases, not that they're duplicated or copied and pasted, but they are very similar from one case to another. They'll generally always say very similar things. Whether that's exactly what happened in your case or not, we'd never know. And that's why CCTV is incredibly important. Now, different police stations, different police forces have different retention policies on how long they retain and preserve CCTV. Technically, and according to a code of practice that was issued alongside the Criminal Procedure and Investigations Act back in 1996, the police do have to retain any material that's potentially relevant to a case or to an investigation. Now, I would always argue, of course, that CCTV is clearly important. Of course, it's potentially relevant to the investigation, and the police should also know that whenever a drug driving case is challenged, it's normally challenged on procedure. If the CCTV or the body-worn video covers that procedure, then clearly it's relevant, clearly it's important, and for that reason it should be preserved. However, day to day, in the real world, it simply doesn't happen. And for that reason, one of the biggest problems that we often face is the loss of CCTV, is the loss of body-worn video footage that perhaps might show the officer cutting corners, or speeding up that process to get that blood sample from you quickly, or perhaps giving you incorrect or inaccurate information in terms of your options in that blood test room, because you don't have to give a sample of blood if you don't want to, and the officer has to explain that to you in a certain way as it's detailed in the M.J. document. So you can wait 4, 5, 6 months for the case to go to court. You don't have to do anything right now, but the danger is that during that time, they'll copy over the CCTV, it's not then being preserved, and that can certainly make my job a lot more difficult when I'm trying to challenge the case or show that certain mistakes were made when that sample was taken from you. Now, an additional point just to make on the issue of preservation is to do with the blood sample. Under Section 15, subsection 5 of the Road Traffic Offenders Act, you are entitled to take your part of the blood sample away with you. You've got the option of having your sample independently analysed at a lab of your choice, and the idea is that you can then compare those results with the results that eventually come back from the police. If there's any disparity or difference between the readings, then that can be a different angle which you can defend this from, different defence argument that you can raise. If you didn't take the sample, however, you might have decided not to take that sample with you. I'd always recommend getting that as quickly as you can. And again, this is another reason why that early intervention is really important, because what we found is that the police don't always have suitable storage conditions at the police station for long-term storage of evidential forensic samples. You know, we're not talking about secure, temperature-controlled, specialist forensic fridges, simply because of the cost involved. So it might be a kitchen-type fridge that your blood sample is being stored in. The problem there is that there's an increased risk the sample gets damaged, an increased risk of cross-contamination. Perhaps when the sample is sent to the lab, it's misplaced. Now, we've all heard of inconclusive blood results as well, and this does happen. If their sample is sent to the lab and the results come back and they're inconclusive, but you've taken your part of the sample, there's no way the police can then prosecute you for the offence, because they need the blood sample to put you over the legal limit in order to bring charges for drug driving under section 5A(1)(a). If you didn't take your part of the sample and they've still got that stored at the police station, they might keep that there for some time whilst they perhaps wait for the results of their own sample to come back. Then they can send that sample off for testing instead, and that increases the chance of you being convicted of drug driving and charged with drug driving. It gives the police a second chance of getting this case in a courtroom because they've been able to rely on your blood sample if their results came back inconclusive or one of those samples was lost or damaged. So if you have been released under investigation and you didn't take your part of the sample, then we can normally make arrangements for you to go to the police station or for that to be posted out to you. You do have that right, and that should be arranged and facilitated by the police. Now, the third P is preparation. So let's say we take this approach of being more proactive. We've had that contact with the police. We've tried to put some pressure on them from a few different angles, but we've made sure they've retained CCTV, body-worn video. Perhaps we've also arranged for you to get your part of the sample as well, so they can't use it. But the case still goes to court anyway. And remember, we can't win every case at the earlier stages. Of course, we'll always try our best for everyone that we defend and everyone that we act for. But of course, there are times that despite our input, the case still goes to court and a client may still be charged. Now, at that point, we are more prepared than we otherwise would be. I mentioned earlier in the video that the police may take 4 or 5 months now to analyse the blood sample. Once the results come back, and often because at that point they're very close to the 6-month mark, they'll push it through very quickly. And you may find that you're in court within a week or two of having received that letter in the post, the postal requisition. And that can be a very difficult, very stressful, very challenging situation to be in, trying to locate solicitors, even affording solicitors at very short notice as well. And a lot of solicitors wouldn't be available at such short notice either. Now, if I've been defending that case from day one, then you and I know each other a lot better than we otherwise would do if I was instructed a week before a first court date, assuming I'm even available at such short notice. So the months that we've been dealing with this case leading up to the first court date, it is not just designed to try and win the case at that stage, it's also planning ahead. If this case goes to court, how do we make sure we are as prepared as we possibly can be? And there is no question that if I've been dealing with this for many months up until that first court date, then I am more prepared, as are you, as to what to expect on that court date. How might we best defend this? What defence arguments might apply in this case? We know that by that point, hopefully, because we've asked them, they've retained CCTV, we've got body-worn video footage that all helps when we're challenging these cases day to day, and might have obtained your custody record from the police station by that point and be able to examine that and study that for the weeks leading up to a first court hearing, rather than everything happening at last minute. And that would also mean, of course, that we know a lot more about this case than the prosecution do, because whilst the police may have been preparing that case up until the first court hearing, the prosecutor that's dealing with this case file on the day may have only received that case file the same day. If they're lucky, they might get it the night before. So there's no time for them to prepare for these kind of cases properly. They're reading your case file for the first time on that court date. If I've been dealing with that case for 4 months, then of course I know more than the prosecution do. And that makes it a lot easier for me to outsmart and outmaneuver the prosecution on that court date, and even just speak with more confidence in court, because I'm so much more familiar with your case than I otherwise would be if I was instructed at short notice or at last minute. So there's various reasons why I always recommend that we try and be more proactive than reactive. And it goes back to these 3 Ps, that we try and put pressure on the police early on. Can we win the case at the early stages and stop you from being charged and prosecuted? That's certainly possible in drug driving cases. Second of all, preservation. Let's make sure that any evidence that's available at the earlier stages that's at risk of being lost or deleted, CCTV, body-worn video being the best but not only example, is preserved, so we can use that at a later stage to defend the case. And then finally, preparation. If it does go to court, then of course we're more familiar with the case. You and I know each other better than we otherwise would do, and we know the case much better than the prosecution does, which makes our job a little bit easier on that court date as well. Perhaps by that point we have a game plan all set out, and we know exactly how we're going to defend this case because we've been dealing with it for the past 4 months. So hopefully that gives you a better idea as to why I'd always want to be more proactive in a case like this. If you're under investigation for drug driving, even if you've been charged and you've got a court date approaching, please try not to worry. Your only option isn't just pleading guilty. Lots of people assume that if they're over the legal limit, that must mean that they have to enter a guilty plea, and that's simply not true. Every case that I've ever defended and won in a courtroom starts with my client over the legal limit. That does not mean that you're automatically somehow guilty of the offence of drug driving, because there's a lot more to consider, to think about as well, whether it's procedure, whether it's the whole process from start to finish, whether it's how that sample was analysed and all the issues that come along with that. So again, if you want any initial free advice, you can find our contact details in the video description. I'm always happy to speak with anyone that's charged or under investigation for a motoring offence. So please get in touch and I'll be happy to discuss the case with you.